The court begins with appearances from both attorneys. The issue arises from a divorce judgment where obligations have not been resolved. The defense argues that inaccuracies were included in the filings, but the judge narrows the matter to key points. At the center of the dispute is whether Ms. Tinsman must remove Mr. Gentry's name from financial obligations tied to the marital property. The concern is his credit has been damaged. He's unable to move forward financially with his own house while her delays continue. More than 2 years have passed without action, raising serious concerns.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion to require plaintiff to comply with the judgment of divorce. Obviously, I've read the pleadings in this matter, Ms. Thomas. You don't have to reiterate those. Do you have anything in response to Ms. McNiff's answer?
Well, there's a lot of things to respond to because there was a lot of inaccuracies in there.
Well, let's respond to the salient points. There was a lot of ancillary and I believe superfluous stuff included, and I don't need you to respond to that.
Okay. All right. So the issue is, of course, whether or not and when Ms. Tinsman has to respond or has to remove his name from the obligation. The concern is that now we've learned that her intent is to not do so for another 18 months. The problem, or to even list the house for sale for another.
Every excuse offered is within Ms. Tinsman's control. They emphasize that the agreement required her to refinance promptly after divorce, yet nothing was done. Payments were missed, affecting Mr. Gentry's credit. Counsel highlights that the divorce judgment was drafted by Tinsman's attorney, leaving Gentry unrepresented. Now, he feels trapped in obligations meant to be cleared years ago. The defense calls the response from the plaintiff's side flabbergasting, filled with distractions, but insists the bottom line is simple. A deadline is required. Without one, his financial stability continues
for sale
to be
for another
jeopardized.
18 months, which would even be beyond that. But the problem of it is that it's affecting Mr. Gentry's credit. It's affecting his ability to do other things at his house and ownership of his house. And so it was supposed to be to hold him harmless. And in the response, there's several things that aren't true, including, who had the affair. I mean, there's all kinds of things. But again, as you indicated, they're ancillary things. The bottom line of it is this case was one where Ms. Tinsman's attorney drew up the document. Mr. Gentry was not represented. It was after he had met with both of the parties, and they both were of the understanding at that point that she was going to refinance and get this taken care of right away. It's now more than 2 years later, and nothing's been done. And it seems that Ms. Tinsman is of the belief that she can do this if and when she wants to, and it is affecting his credit. It is affecting, there's all kinds of excuses, but every excuse is one that frankly is under.
When questioned by the judge, plaintiff's counsel admits no timeline can be provided. They argue refinancing is impossible until 2 years of financial records are obtained. Yet this creates a problem. The judgment never specified a date for refinancing. They claim the court cannot now alter that agreement. However, the judge is clearly dissatisfied. Nearly a year has passed since the judgment, yet no resolution exists. The court is not willing to wait indefinitely while excuses continue. Without a firm plan, the judge begins considering stronger remedies. The patience of the court is visibly running out.
Ms. Tinsman's control. We just are asking for a date by when it needs to be done, because one wasn't put in the initial judgment of divorce that was prepared by Ms. Tinsman's attorney. And then again, the amount of things in the response were a little flabbergasting for us, quite frankly, but there are 5 missed payments according to the document from the credit union. And so we're just simply asking that there be a timeline put on this matter.
Okay, thank you. Ms. McNiff, you talk about all sorts of things in the response. What's the date that she'll have this refinanced by?
Your Honor, as we responded in detail, the problem she's going to have is that the financing companies want her to have 2 years of either W-2 or 1099 wages, and she simply doesn't have that.
The judge takes a firm stand. He reminds both parties that sufficient time has already been given. The judgment was finalized in February 2023. That means close to a full year has passed without progress. The judge stresses that financial disputes tied to a divorce cannot remain unresolved forever. Because plaintiff's attorney cannot provide a date for refinancing, the court decides the property must be listed for sale immediately. If refinancing somehow occurs before the sale, the court will review it. But unless that happens, the property must be sold without further excuses.
She won't be able to refinance until then. She certainly wants to sell the house sooner than 18 months. But we need a resolution of the parenting time issue. I'm going to have to file a motion, I think, to resolve that and to get that to a hearing.
Okay,
But
that's not before me today.
No, I'm just, and I understand that. She has an
Give
intent
me
to
a date.
sell.
Give me a date.
I don't have a date, Your Honor. I don't. But the big thing here, Judge, is a judgment of divorce for the property provisions is really a contract. And it's not for the court to reform the party's contract. It should have been on Mr. Gentry to ask for a date when he wanted his name off of that property. And without that being in the judgment, there is no date. I think that
Okay, that's fine.
Mrs. Tinsman will do it, but the judgment speaks for itself.
Okay, well, in this matter, it's been approximately, the judgment was back in on February
The
3rd.
ruling is clear. Ms. Tinsman must provide a listing agreement to opposing counsel within 14 days. Requests for additional time due to holidays are denied as the judge insists ample time has already passed. The court refuses to allow further delays, citing damage already caused to Mr. Gentry's credit. The order stands firm. Sell the house or refinance immediately, but no more extensions. With that, the matter concludes, and the judge closes by wishing both sides a good holiday. The decisive order ensures accountability after years of delay. The case is adjourned with finality.
2023. So we're going on close to a year. Obviously, that's sufficient time to get the matter resolved, and the court's not going to wait indefinitely for the plaintiff to qualify or whatever. And because we can't be given a date, the court is going to order that the house be sold, listed for sale forthwith, and be sold. If something happens in the meantime, she's able to refinance, the court would consider that. But at this point, if there's no date, that she's going to have to list it for sale and have it sold forthwith, and provide Ms. Thomas with the listing agreement. I will require that be done within.
The courtroom drama ends with a powerful reminder. Divorce agreements carry lasting consequences when ignored. Ms. Tinsman believed she had unlimited time, but the judge made it clear. Delays have limits. By ordering the immediate sale of the Sheed home, the court restored fairness and accountability. Mr. Gentry finally gains relief from years of financial strain, while the ex-wife faces the weight of her choices. Justice does not wait forever, and excuses will only go so far. In the end, the gavel came down hard, ensuring closure and a lesson about responsibility that won't be forgotten.
Within 14 days of today's date.
Judge, could she have a little bit more time just
Nope.
due to the holidays? It's going to be
She's had
difficult.
sufficient time. She can do it within 14 days. Thank you.
Thank you, Judge.
Thank
got it.
you.
You can submit that, Ms. Thomas, under a 7-day.
Will do. Thank you.
Thank you. Have a good day and a good holiday.
Thank you.
Thanks, you too.